I signed a confession in a language I did not speak, in a room I did not understand, with a man sitting beside me who was supposed to be translating my words but was translating something else entirely. I am going to tell you this story the way I experienced it, which means I am going to tell you a story about exhaustion, not the dramatic exhaustion of a film, the real kind, the kind that comes from spending 14 months inside a legal system conducted entirely in a language you cannot speak, trying to understand what is happening to you through other people's summaries of other people's decisions about your life. My name does not matter for this story. I am a man who came to the United Kingdom 4 years ago. My English, at the time of my arrest, was limited to perhaps 60 functional words. Yes? No, please. Where? I do not understand. That last phrase, I do not understand, I had learned specifically because I had been told it was important to say it clearly and loudly if I was ever in a situation where I needed help. I said it 17 times in the custody suite. The record shows 6. The arrest happened on a Thursday evening in February. I had been at work, finishing a shift at a food processing facility in the Midlands, and 2 officers had met me in the car park. I did not understand what they were saying. I understood handcuffs. I understood the car. I understood the building they took me to. In the custody suite, I was told an interpreter had been requested. I waited for 3 hours. The interpreter who arrived, a man I will call the interpreter, because his name is part of an ongoing process I am not permitted to discuss in detail, was of the same national background as me. He spoke my language. He introduced himself as a certified court interpreter. He sat beside me for the interview. I want to be precise about what happened in that interview, because the precision is everything. The officer asked questions in English. The interpreter translated them into my language. I answered in my language. The interpreter translated my answers into English. I could not verify whether what I heard was what was asked or whether what I said was what was recorded. What was recorded in the interview summary was a series of admissions that I had not made. I know this because 14 months later, when I finally had a solicitor who had the full interview recording translated independently, I was able to compare what I said with what was attributed to me. The gaps were not small. 2 minutes in, I want to stop and ask you to consider something. You are in a room. You do not speak the language. A man sitting next to you is supposed to be your voice. You have no way of knowing whether your voice is being used. You sign a document at the end because you are told it is required and you do not understand that you can refuse. You do not know you have refused nothing. You do not know what you have agreed to. What would you have done? I have been asked this question. I do not have an answer that satisfies me. The solicitor who finally understood what had happened to me was a woman called Amara, criminal defense specialist, fluent in 3 languages, with the particular quality of someone who reads interview transcripts the way other people read contracts, looking for what is missing rather than what is there. Amara had been assigned to me 18 months after the arrest, after 2 previous solicitors had treated the confession as the foundation of the case rather than a potential problem with it. Amara requested the original interview recording. She had it translated by an independent certified translator. The discrepancies were significant. The most significant was a question the officer had asked about my relationship with the alleged victim, to which I had answered in my own language, clearly on the recording, that I knew him from the community but not personally. The interpreter had translated this according to the English summary as he confirmed he had a close personal connection to the victim. Confirmed. The secondary character was a man I will call Yusuf, no relation to me, same national background. same community with a case that had been processed through the same custody suite 2 years earlier, involving the same interpreter. Yusuf's case had been dropped before trial. The reason for the dropping was documented in his file as insufficient evidence. Amara had found the file. She had spoken to Yusuf. Yusuf had told her that he had also disputed the accuracy of the interpretation in his interview, and that his solicitor at the time had raised it formally, and that the formal raising had gone nowhere. The same interpreter, a prior complaint, never investigated, never disclosed to me. The midpoint is when Amara received the medical assessment. The custody record showed that during the 3-hour wait before the interpreter arrived, I had been assessed by a custody nurse. The nurse had noted elevated distress, difficulty following instructions, and what she described as dissociative presentation, a state in which a person is present but not fully processing their environment. She had recorded these observations in the custody log and had flagged that an appropriate adult might be required. No appropriate adult was provided. The medical assessment Amara commissioned, conducted by a forensic psychiatrist 18 months after the arrest, concluded, based on the custody record, the nurse's notes, and an assessment of my presentation at interview, that at the time of the interview I had not been fit to be interviewed without an appropriate adult, and that the interview should not have proceeded without one. The admission was, in the forensic psychiatrist's professional opinion, obtained under conditions that compromised its reliability. The judge who heard the application to exclude the confession was not the judge who had presided at the previous hearings. He read Amara's submission. He read the independent translation. He read the medical assessment. He read the custody record. He read Yusuf's file. He excluded the confession. Without the confession, the prosecution's case was significantly weakened. The charges were reduced at trial. I was not acquitted entirely. There was independent evidence relating to a secondary matter that the judge allowed to stand, and I received a community order rather than a custodial sentence. Partial win in the language of the law, in the language of what it cost: 14 months of my life, a job I lost because of the arrest, a flat I could not keep without the income, and the particular permanent damage of having been a person who signed something he did not write in a room full of people who were supposed to protect him, while a man who was supposed to be his voice was speaking someone else's words. The bittersweet part is that the complaint against the interpreter is under review. Amara filed it formally. It is moving slowly. I have been told not to expect a quick outcome. I have been told this by people who are familiar with how quickly these things move, and their familiarity has not made them optimistic. I am not optimistic either, but I said I do not understand 17 times in that custody suite, and the record shows 6, and I want the number to be correct somewhere, even if it is only here.